I would like to introduce you the case of National Research Development Corporation and Commissioner of Patents. This is the leading decision in Australia for the test of whether an invention satisfies the manner of manufacture test within the meaning of Section 6 of the Statute of Monopolies. It is a landmark case for helping shape what can be regarded as patentable subject matter. This case was an appeal to the High Court following a rejection by the Deputy Commissioner. The patent in question was a process of mixing identified chemicals together and applying the mix to alfalfa crops in specific quantities in order to eliminate weeds, in doing so not harming the crops. The patent was for the method of producing a weedicide, and importantly, the chemicals used were previously known. The Deputy Commissioner had rejected the case because it was considered that this was merely a use of a known substance, which did not result in the creation of a physical or tangible vendable product. However, the High Court allowed the appeal, interpreting the following key principles. Firstly, the High Court applied a broad approach to find that the process was in fact patentable subject matter. They focused their decision on whether the proposed patent constituted a manner of manufacture. They highlighted that the term is a dynamic concept that has evolved in common law since the Statute of Monopolies. The court were flexible and recognised that technological developments and inventions are forever improving and unpredictable, regarding the NRDC process as scientific ingenuity. And although not perhaps envisaged at the time of the Statute of Monopolies, should nevertheless be recognised for its inventive nature. The court confirmed that a manner of manufacture must be a vendable product, explaining that be an artificially produced state of affairs. They understood that a process is a vendable product where it offers an advantage to the useful arts in material form. They held the NRDC case did offer a useful art, highlighting that the detailed specification is a new, artificially created process for ridding crops of certain kinds of weeds. They argued the fact that the substances themselves were already known to man afforded no valid reason for denying that the suggestion was inventive. The chemicals used formerly were supposed not for the same purpose, not this kind of purpose at all. The court pointed out that these chemicals were not proposed to be used in a way which was formerly well understood, and that the idea of using them for the current purpose involved invention. The court also found that agricultural and horticultural inventions should not be exempt from patent if they do meet the necessary requirements. Finally, the court confirmed that to be a manufacturer, the patent must be of economic significance. Its value to the country must be in the field of an economic endeavour. They agreed. This was the case here, as the NRDC process could be commercially traded, being of social benefit and value. To conclude, the court found that there is manufacture, such as might properly have been the subject of letters patent and grant of privilege under Section 6 of the Statute of Monopolies, wherever a process produces, either immediately or ultimately, a useful result. This adoption of a broader definition of manufacture is a landmark principle in Australia's patent law.